Hi, everyone. Welcome. I'm so happy to see so many familiar faces here. I'm just going to share my screen for a minute. So let me do that. Yeah, so this is exciting. Not really, but of course. Let's see here. Why won't it let me do this? Okay, there we go. All right, so exciting stuff. Changes to the laws are always so much fun because now we all have to figure out how, in fact, we can sort all of this out, and how this is really going to change what transactions look like for us. And certainly that is going to happen. This is, a major item that really largely up until this point, as everyone knows, most sellers just didn't even engage in this. It wasn't even a thought. It was a statement. This is what it is. And then we moved past it. So now we really have to figure out what we're doing. So this is just a little bit, this is going to be largely question and answer. I'm just going to put that out there right now. I have a short presentation prepared. But really, I know so many of you just have questions and you want to talk about it, and that's totally fine. But we'll quickly just run through the existing property condition disclosure statement. The reason why is because I know so many of you, all you were doing was basically telling your clients, listen, talk to your attorney, but you probably shouldn't give this, right? So many sellers didn't even ever even see the document, let alone start to work through what it looks like and your involvement as an agent in that. What are the changes to it? We'll talk about that. Exemptions remain largely the same. So we'll go through those because those are going to be super important now. And then, basically effectiveness, how we're going to move forward, both on a buyer side, a seller side, and on your side. So all important stuff. And then of course we'll do question and answer. So the current property condition disclosure statement, this is available for you on hopefully, can everybody see this? I'm hoping so. But basically this is available on New York State's website. Your brokers also probably have it, but this is what it looks like, right? So this is a form that now the seller will have no choice but to complete. So they're, unless they're exempt, they are going to be completing this statement. So here are the questions, things that the buyer really, it's nice for them to be aware of. So the biggest part here are, we're going to be adding in some questions, or they're going to be adding in questions regarding flood zones and things like that. So so this is what the statement is currently. I'd like to start up here at the top. There is a representation here, instructions to seller, and then seller statement. So the seller makes the following representations to the buyer based upon the seller's actual knowledge at the time of signing this document. The seller authorized his or her agent, if any, to provide a copy of this statement to prospective buyer, for the property, basically. And then also a representation that these are of the seller. Okay, these are not of the agent. So that's super important for you guys. But the problem is that, when we fill this form out, there's always a chance that things don't go quite as they seem. Maybe the seller forgot. What happens when you have elderly clients? They've owned the property for 50 years, right? They totally forgot that 47 years ago, they had that terrible, flood in their basement and whatever so it's opening up all of these, questions as to how do we address that as a seller? How do we, make sure that we're disclosing what we're supposed to be disclosing? And so on and so forth. So this is the current form. So going back over here, okay. Changes. So the major change is that everybody's got to do it. There's no choice. No option anymore. If you're not exempt, you've got to do it. Okay. As far as the credit, there is no credit. So exempt properties, there's just nothing. And that would have been the case prior. So there would be no credit in that case either. And the form has to be attached to the contract. So it's going to be part of our binding contract, which is a huge change for us because if you recall, all the representations were really to the best of seller's knowledge and not to survive closing. So now here we are attaching a bunch of representations that are going to survive closing. So totally different. We also have additional disclosures regarding flooding that they added in there. So quickly here, a lot of you probably already know this, but these are the exemptions to the law. So these are the times that the seller doesn't have to complete the statement. They also wouldn't be giving the credit. So when we're transferring property in a foreclosure, we don't have to do that. Most commonly, we're going to be looking at these exceptions here. So typically, when we see a co-op or specific condos don't have to complete this statement, new construction doesn't have to complete this statement, and a fiduciary serving in the administration of an estate. So this one is a common one that I get questions on even now. If your clients own property in a trust and they are still alive, they have to complete the form. The exemption applies to the administration of the estate by a trust. So because in that case, what you're doing is a fiduciary is completing the statement. Well, the fiduciary doesn't know the answers to a lot of these questions. They wouldn't have the personal knowledge. So therefore they say, okay, well, fine, you don't have to do it. Well, if, the people that own the property simply put the property into a trust and then they sell it, well, they would have the knowledge. So that in that case, they would be required to complete the statement. This comes into effect March 20th. The timing of it is the biggest question that I've gotten so far. How do we deal with the timing of it? Well, technically it's any contract entered into needs to have this attached to it beginning on March 20th. So my perspective is that as listings come up, that from this point basically forward, that you're getting this form done, because all it's going to do is result in a delay. So as listings are going live now, you probably should have this form ready to go and complete it. We'll talk about where we should maybe place that form. But it should be ready to go, because if we wait and we start entering into contract negotiations, let's say next week, well, those negotiations could end up extending a little bit longer. And now we would be even further delayed by having to go back and disclose the statement, review the statement, and have it, be a part of the contract. So that would be my suggestion, is just start getting it going now. Changes. The 7 questions regarding the flood status and experiences are going to be added there. You can probably imagine why they made this change. In my opinion, this change probably was reasonable. It's the fact that they gave the seller the option, or removed the seller's option to complete the statement, that's slightly unreasonable, for our industry. But the actual fact that they're, adding additional questions, based on what we've experienced in New York over the last, decade, probably, does make sense. So what sellers and buyers need to know? Well, the seller needs to know that they have to complete the statement. So, this is going to be part of your listing paperwork now. This is something that they, should fill out. I've got a lot of questions of whether the agent should help. I don't think that there's really anything that there is for you to be able to help with. They're going to ask you questions. Of course, they're going to ask you questions because you're their agent. My advice would be, and a lot of you do it now, when you're listing the property, have them hook up with their attorney then. Whether it's the attorney that they've used for their, all of their transactions and they know them very well, or whether they're asking you for recommendations, have them certify that now. So that way, it's underway. And if they do have questions when they're completing the statement, it gives them the ability to start asking those questions now. Also, there may be ways to answer the questions in which they need to provide more information, but there's a question as to how to provide that information. So again, having attorney advice early on may limit, issues down the road, once we get into contract discussions and all of that. Buyer has to sign off on it too. So in the very limited number of transactions over the last 9+ years that I've been doing this, that in that time frame, the handful of clients that I've had complete the statement, Well, oftentimes what happens is we send it as part of the contract. And then when we send it over, they would do the partially executed with this form, right? So they would sign the contract and they would sign the property condition disclosure statement. So that's not in of itself probably going to be a timing concern for you. What the timing concern that I would think is that if there are issues or questions that are given in this statement, now that's going to take the buyer time to look into. So my thought process is you may be better off giving them this statement prior to their home inspection. So that way, if there are issues that were disclosed, they would have had the opportunity to have their inspector look into those issues, which is really a good thing, not find out about them after the fact. And as you all know, the home inspector can only see so much when they go to do the inspection. So, having personally witnessed them before, they're not going to be moving, a bunch of stuff to get, behind a shelf to see if they can see something, right? So if they have this information and there is something that needs to be further investigated, they would have the opportunity to do that still within the time frame that you would already be anticipating for inspections. So my thought process is probably the sooner that you deliver this to them is going to be better than just waiting until we are initiating contract. And stuff for you guys to know. So the current form I have linked here, but again, it's on New York State Department of State's website. So this form we're being told is going to be updated. This one was revised, looks like June 2023. So we're still probably waiting for the most updated version to be published. For now, I guess, use what we have because I'd rather deal with just updating the new statement. If it posts, let's say on the 20th, then we can deal with that. But at least you'll have something in your hands and it won't be something that your seller's like, oh my gosh, I have to complete the 6 pages and now that's going to take me 2 weeks to do because I really have to sit down and look into it. So just use what we have for now. And then going forward, if a new form is published, we'll put it out. We are watching for it. Sharing it, like I said, prior to an accepted offer, or, I mentioned sharing it prior to contract. This is going to be, something that you and your brokers might work out a better plan for this. I was speaking with a few brokerages regarding this, and there was a suggestion of maybe finding a way to put this in documents that can be accessed by all the agents that are looking at this property. That may be a good way to do it. Or the other alternative would be, soliciting your offers, taking in those offers as you normally do. And then when again, scheduling a home inspection, or if they're waiving inspection, maybe sharing it with the accepted offer at that time. So, again, probably a more, brokerage based, decision as to what's best for everyone to be doing. Whether you want to be sharing it, just with anybody who can see it, or whether you're going to limit that to just the accepted offers on the property. Language to use in the property condition disclosure. So this is, something that, like I said, hooking up with the attorney early on, there may be a way that we need to write certain statements. Maybe they do have knowledge of something, but maybe there wasn't a ton of investigation for it. So while they have knowledge, it's very, very vague. So it says, if yes, explain below. Okay, and they give you 2 lines to explain. So how are you writing the explanation? Well, there may be a way that it needs to be written where the disclosure is being made, but the seller's not opening themselves up to additional liability because of the way it was worded. I mean, again, these are, people that are just selling their house. It could be the first time that they've ever sold a house. And they are like, well, yeah, I mean, we had this issue, but it wasn't really a big deal. But, the way it looks like a huge deal. So, right. So how do we word that to really limit potential exposure and liability for the sellers, but also still give the buyer the information that we're supposed to be giving them? And then the effect on transaction timing. Like I mentioned, we can't have a fully executed contract now, starting March 20th, without the property condition disclosure statement having been signed off by the buyer. So my seller can't sign off on that contract without it. So I think in the beginning, while we sort all of this out, there's likely to be delays. And that's just because, again, we're adding in another thing that's got to be done before we can even share that. So it's really important that we are sharing it ahead of contract to try to expedite. But if we are sharing it on contract, I mean, the buyer's probably going to want some time to review it prior to, you know, signing off and remitting partially executed back to us. So I think as we get into more of a groove, I think this will work itself out timing wise, but in the beginning, yeah, I could definitely see that we'll probably have some delays. All right, so what you've all been waiting for, questions. Let me see how we can do this. You can type questions into the chat, already have a few. Oh no, you can't see the disclosure. Oh man, that would have been helpful to see earlier. Let me go back and I'm going to put the disclosure up earlier. So went too far. Click this and stop sharing and then share this portion of it. Okay. Okay, now you should all see the property condition disclosure statement. Okay, so this is what it looks like. Okay. Now let's jump into questions. Condos are exempt. Yes, they remain exempt. How do you know if it's exempt? Because some things look like a condo, but are actually not a condo. Look to see if on the Orange County property card, if there is 0.01 for the lot size, or if there's an actual lot size, like land. One, you know, could be like very small, of course, because it's a townhouse, but is there land going with it? That's one way to see. Also, sometimes on the property card as well, the Orange County property card, it'll say in the legal description condo, and then you could see that it's a condo as well. So that would be two ways to know. Also, again, check with the attorney, make sure that, you know, it is, and you're not going to have your client fill it out then. Okay, let's see. Next question. What language should go into the contract to protect the seller and the lawyer from any post-closing litigation? Great question. So we are going to be drafting contracts a little bit differently. We will include language in there that we are delivering and have delivered the property condition disclosure statement with representations made by the seller to the best of seller's knowledge without further information, belief, or investigation. So what we're saying is we're giving you what we can give you, but you know, it is what it is. We're also going to add in some language that the buyer has been presented not only with the document, but the opportunity to investigate further by conducting their own inspections. So the goal there is that we are trying to limit our seller's liability, and we may modify this language as time goes on. But, you know, we're trying to create some type of limitation there. And we'll talk, I think there's another question that's going to get to what I was just about to say anyway. Do you foresee sellers having to get an expert to investigate and issue a report on things that were vague, but could appear big, like you mentioned as the example? I would shy against that. A lot of people have actually asked me, should my seller do a home inspection? Well, no, because now they're going to know about all the issues. The whole point of the statement is that they're just representing what they know. So if they don't know it, then they should not be disclosing it. So if you call in a home inspector to do a prelim inspection before you list the property, and they say you've got these 65 things wrong with this house, you technically, if they fall into this statement, which I'm sure a lot of them would, you would have to disclose all of those. So I don't think that would be necessary. I think instead what you're better off doing is, you know, again, just telling the seller, you know, you have to make these statements. They're to the best that you can make them to what you know. then then any further commentary they might want to word that with their attorney. Okay. And is property condition disclosure statement required if the deal goes under contract before the 20th, but close after the 20th? From my understanding, the way it's read, the way the law reads, I should say, it's the contract that's entered into closing or entered into after the 20th, sorry, prior to the 20th. We're not going backwards and making the disclosure, but if the contract is entered into the 20th on, then it does have to be there. If the property is completed with no issue, disclosure is completed with no issues, how would somebody know if there was prior knowledge? That's a wonderful question. So I've had this come up. We've all had post-closing issues. The client calls up and they say, we had an issue with the septic backed up. We had an issue with lead paint. We found lead-based paint in the property post-closing. What can we do? And largely up until this point, the answer has been nothing, because they have not completed the property condition disclosure statement. So they have the limitation of liability, and it's just not worth pursuing from there. I had one situation come up where I said, really, in our contract, we do make representations. They're made to the best of the seller's knowledge. That we make that very clear, and they are not to survive closing. And the client was very upset because they said the seller outright lied to them. I said, oh, what do you mean the seller outright lied? They made the representation to the best of their knowledge. Maybe they just didn't have knowledge of it. And she said, well, because we called a company to come and fix the issue, and they said that they've been to the house 2 or 3 times and had reports with the seller about this issue. So they did outright lie that they knew about it. So in that case, I mean, that's the kind of stuff we're thinking that could happen, right? So if you called ServPro to come out and service the house because you had, a flood, and you don't disclose on the disclosure about the flood, and they find out, well, there's a clear way to see that there was an issue that wasn't dealt with. So, or that wasn't disclosed properly, and that could put the seller in a place of liability. So that's concerning. And then, will the lenders have access to the form? Do we have to provide it to them? Also a good question. It's going to be attached to the fully executed contract. It states that it's required to be attached. So unfortunately, I think, yes, I think it's going to be shared with the lenders. It specifically, requires that, almost like an addendum, I guess, to the contract is how we're going to have to start looking at it. So yes, and okay. All right, so I think I got through all of the other questions, but let me see, do we have anybody like raising their hand or anything? Yeah, Karen, maybe once. Okay. Okay. Karen, did you have a question? Maybe. You're muted, so we might not be able to hear you if you are asking it. Oh, all right, Harriet. Go ahead, Harriet. Have a question?
Yes, it has been my experience that sometimes sellers know things and they don't tell it, and some of them are quite substantial. Like I just sold a property where there was damage to the actual integrity of the property itself. It was falling down. So how do you handle that when you can see it and they don't disclose it?
Well, I mean, really now they'll have to, they're not going to have an option, but to disclose, the condition of the property. And that may be a situation where an addendum is attached to this form to talk about what that condition of the property is. Certainly we've all done transactions where the property is like either completely gutted, or, you know, in significant disrepair. And there might be a lot of answers that can be made to this statement, but there also may be, on certain questions, there may need to be a reason, like, you know, the property is currently, you know, in extremely run down, you know, condition, or there may be, you know, multiple violations on the property or things like that. So probably an addendum, if it's needed, depending on the situation, will have to be, you know, completed. Timothy, you had a question? You're muted if you do.
How about now?
Now we can hear you.
Oh, cool. I had to duck out for a couple of minutes, so if I missed it, I'm sorry. Are the questions the same as they were on the previous form, including unknown?
We haven't seen the new form, so we're largely thinking that the answers, yes, no, unknown, and NA will be the same. However, there are going to be, I think, 7 new questions added specifically with regard to like flood.
So in the case we were just talking about, are the walls falling down unknown?
Unknown, unless they know that the walls are falling down, then I guess it is known. You know, so yeah.
Okay.
Okay. And then Nina, question?
Yes, hi. So the 6-year liability window afterwards, that seems on kind of like
Substantial.
uncannily long.
Yeah. Yeah.
I mean, a lot can happen in
Agreed.
that time. Like how can your seller defend themselves, saying like, well, how could they prove? Or like, who has the burden of proof in that situation? The buyer, I suppose. But how could the seller
It's a
defend
lot.
themselves to like, no, it really wasn't an issue when I lived there.
Yeah, and you're bringing up exactly, you know, what I was going to touch on at the end. At the end of the day, to enforce this, it's litigation. So I will tell you that I have received many calls post-closing that I've had to deal with, you know, where there were issues that came up. And the argument back, you know, to the client is like, I get it and I understand and it really stinks, but how much is it going to cost you to fix it, right? Are we talking about like $2,000, $3,000? I'm not saying that's not a lot of money. That's not what I mean. But when a retainer to hire an attorney is upwards of $5,000 to $7,500, depending on the litigation matter that you're looking at, which is probably what this would be, to go sit in litigation for probably in the neighborhood of, I would say, 2 to 3 years, to sort through, you know, mounds of documents. And that's a retainer payment to the attorney, by the way. That's not the total amount of fees that you might end up paying. And maybe at the end of the day, you've got a really great case and you win your case and maybe it's the quickest, you know, verdict that you ever got. Now you got to collect on that money, right? So let's say you got a $10,000, $20,000 judgment. Well, now you got to collect on it, right? So first of all, where's the seller? Are they in California or did they move down the road? Because now you're talking about jurisdictional questions. That in of itself will be a problem. If they're still located in New York, okay, fine. We've got jurisdiction to an extent we can proceed on a normal, in a normal way. But even in that regard, what if they don't have any money? Right? Like now, if they don't have any money and you just spent 3 years and $20,000 in attorney's fees to fight over a $10,000 issue, even though you won, if they don't have money to collect against, then that was a big waste of time. So the actual practicality that comes with having to litigate an issue under this document is really something that, attorneys like myself are going to be having those discussions with our clients saying, listen, can we do it? Can you sue them? Can you? Potentially, right? You have a claim, but what does that actually look like? And does it make sense? That's, there's a cost benefit analysis here. So, I have plenty of clients that have had issues like, let's say in new construction, right? And so it's like, okay, well, we could make a claim against them, but we're talking about, again, a low amount of money for you to go and repair it yourselves. Honestly, if it were me, I'd probably just go repair it myself because I know what the back end looks like. And I know what that time frame looks like. And it's just at the end of the day, I don't know that it's worth it. If it's a big issue, then yeah. And unfortunately, a seller, 5 years after having sold the property, if they, find out that they're being sued, they're going to have to deal with defending a claim against them, that, that they probably don't readily have a lot of access to, the documents for that. So sellers will have to be, keeping better records and all of that to really make sure that if there are issues that they've retained those records post-closing. One of the questions that I did get from another agent that I don't know that's on today was what happens when something changes after this is signed, but prior to the closing? So that question's really good because it does state in here at the end. Okay, so seller certification. So seller certifies the information in this property condition disclosure statement is true and complete to the seller's actual knowledge as of the date signed by the seller. If a seller of residential real property acquires knowledge which renders materially inaccurate a property condition disclosure statement provided previously, the seller shall deliver a revised property condition disclosure statement to the buyer as soon as practicable. In no event shall a seller be required to provide a revised property condition disclosure statement after the transfer of title from seller to the buyer or the occupancy of the buyer, whichever is earlier. So on a pre-occupancy situation, that's almost essentially like closing. They don't have to redisclose anything. Why? Well, because the buyer's in possession of the property. So why would they be disclosing? They have it readily in front of them. As far as the actual knowledge and what is materially inaccurate, well, that's going to be the best lawyer answer I can give you. And that's going to be, it depends. That's where the attorney comes in. That's where we have to start looking at everything and saying like, okay, well, what is the issue? I usually tell sellers, with regard to reasonable wear and tear, something really, really minor, small scratches on the floor, taking a picture down, leaving small holes in the wall, things like that, that are just so minor, we don't care about it. Well, now we have to figure out what is materially inaccurate. And that's really, unfortunately, going to be a case-by-case basis. What happened and do we need to disclose it under this? And a redisclosure would then have to be prepared and signed off by everyone. Now, does that give the buyer the right to cancel the contract if we have to do a redisclosure of the property condition disclosure statement? Well, that could be a potential, depending on what exactly happened. Right now, the seller's obligation is simply to restore a property back to the same as is condition. So in this case, now we're talking about potentially changing, that by having to redisclose an issue that came up and whether the buyer can question that now and refuse to sign off on an update. So I have more questions that came through. It was my understanding that the property condition disclosure statement needs to be available to buyers looking at the house. Is it okay to just provide to the buyer who has an accepted offer? I don't know that it has to be provided to everyone. Based on the statement, like I said before, when we've done it, we've only sent it as part of our contracts in the beginning when it was sent out. But again, that also could be a brokerage, or, NAR could come out, I don't know, the local MLS can come out and say, no, we want this to be disclosed ahead of time, and then best practice would be to do that. My thought process is you probably are better off just putting it out there before even having accepted offers. And the reason because of that is like, if it does disclose an issue, why even waste time, right? Why not just have it out there and then, maybe that affects the offer that comes through a little bit or changes, certain buyers that are looking, they may not want to, proceed. And so it would just be wasting the seller's time if they received that offer and then had it rescinded by the buyer. So also, neighbors may unknowingly give buyer information about the house after they move in. True. True, you got eyewitnesses, right? Living right next door. So, yeah, I mean, you know, supposedly, I guess if you needed to bring a claim and the neighbor's willing to go to bat for you, they might be a good witness to say, well, they had so and so here, and you know, I mean, there could be a lot of hearsay there, but if it gives them enough information that they can dive in and get you know, further like documentation on it, well, you know, now that might be an issue that does expose the seller to liability. I just need to know if the paperwork goes for all property, even if you live in other states. I'm assuming that means that if you own the property in New York, but you reside elsewhere, do you have to complete the statement? The answer is yes. So just because you live in Florida does not mean that you don't have to fill out the New York State Property Condition Disclosure Statement. So just a side note on that, this form, or very similar version, I should say, of this form is actually required in a lot of states. New York is one of the states that provides the sellers with the option to complete it or the option to give the credit. In other states, it is a requirement that this be delivered. So that's really probably one of the reasons why New York is moving that way, is because they saw that other states do it as well. What about buy and flips with LLC investors? Will they need to complete it? Yes, just because they're an entity does not make them exempt from completing it. But again, they are completing it to their knowledge. So if they've only owned the property for 6 months, they might not have knowledge of an issue that happened 10 years ago. That's why you can see that, you know, their knowledge, you know, will be more limited than a seller that's probably owned it for 50 years is going to have a lot more to disclose and explain. How long is the seller liable after closing if something comes up? Technically, I would say it's a breach of contract statute of limitations of 6 years. So that would be, you know, the amount of time that the buyer would have to make the claim. If there is an issue that arises on the form that the seller gives a credit at closing that they agree upon, does this satisfy, or can the buyer come after the seller years later? That's a fabulous question, because yes, I mean, if you've made a disclosure here, all it's saying is that you've properly made the disclosure. If you're sorting, I mean, there could be no credit given, right? There's plenty. I have a client that I just finished a contract review for, where he told me that there's significant issues with the plumbing, and the agents are on this Zoom right now, right? So he knows that there's issues with the plumbing. He's got to deal with it later. It doesn't allow him to go after them post closing. As long as in that case they would have made the disclosure. You know, it's if you give a credit for it, you know, the buyer finds an issue, and this is a good question, right? So like if you have your disclosure statement, you send it out, you know, part of your list, your paperwork, you know, when you're uploading to MLS, or you have a way that they can access it. And then the buyer goes and does a home inspection and finds all these other issues. Now what happens? Do we have to redisclose because the seller has knowledge? I mean, this is where we start getting into all the nitty gritty. You know, what do we have to do now? Now, if that buyer backs out and we go to a new buyer, do we have to do a new disclosure statement because we are aware of these 10 issues that the buyer found during their home inspection? You know, there's definitely a situation where that could be the case. And I think that's, again, attorney involvement in the beginning, because we need to make sure we're doing it the right way. There was a question that came up from another agent that if in the event they do the home inspection and they find you know, a ton of issues, and they send you the report, or this came up actually, it was with lead-based paint. They had a lead-based paint test. They send the report to you. Well, you would have to disclose to your next buyer that there's lead-based paint and that the seller has knowledge of it, right? So if we follow that same thought process with an inspection report and this disclosure statement, there is a chance that, again, we would have to revise the disclosure based on that. And if this stops, what is the right legal steps to make sure this doesn't happen? So Caitlin, that was going back off of the question of if the issue arises on the form that the seller gives a credit at closing that they agree upon, does that satisfy it? And if it stops, what is the legal steps to make sure that doesn't happen? I don't know that I quite understand, but Caitlin, maybe I'll unmute you and you can ask that question. Go ahead, Caitlin.
It's actually a question from George Kadunas.
Okay. Hi,
So,
George.
hi there. So this and identify an issue of the form. The buyer knows about the issue, they come to an agreement, and the seller gives a credit. And they go to, they close the title transfer. A year later, have the buyer come back and reactivate that issue, or that stops.
Well, as long as they disclosed it, then no, they can't reactivate the issue. If the buyer finds the issue, then I think that we would have to address that in where we put the repair addendum, or where we put credits. We would probably have to outline the fact that the buyer, did their own investigation and found, issues, and tried to cover those and state that that's,
So you'll be an addendum to that form, say it was a termite issue, and they got a credit for that. You'll be an addendum to the contract.
an
Right.
addendum, yeah, because the property condition disclosure statement is an addendum. So we could follow that up with an addendum to the contract to cover that, yes, this was addressed in this way, so therefore the buyer's aware of this issue that they found,
Okay.
that they located. Okay, what about making a walkthrough list of items to verify? Oh, you found a new one? Oh, Val just came and brought me a new form, so I bet you this is the new one, so we'll send the link out to everyone. She's been checking. So let's see, what about making a walkthrough list of items to verify as of the date all things listed on the form are in whatever choice condition and signed by the buyer? Kathy, I'm going to unmute you so that we can talk about that a little bit more. Okay. Go ahead, Kathy. Kathy, are you there? Okay, now you're there.
I was thinking that might be a good way to set that you are passing the house to them in certain conditions. We're talking about even scratches on the floor. You can't verify what they've done in the 5.5 years that they've had it. But if you made a walkthrough list of everything that you can possibly think of, and they sign off on it, that, oh, there's a scratch here and but I mean, even what about boilers? You can't warranty your boiler for 6 years, or your hot water heater, or your roof.
Yes. So my suggestion would be to not do that, because what if you miss something? And then now it's not there. That might be more of an issue. So I don't know that, and I don't know that as an agent, you really want to get involved in that. I think that this is really, as the agents, the seller needs to complete this truthfully. And your involvement, should be rather limited. Because we certainly don't want a situation where you advise the client to say something, or to say, oh, no, check off unknown, and then that ends up not being true, or there's an issue. So I wouldn't personally want to be responsible for a walkthrough list or anything like that. As far as, questions on a boiler, on appliances, on things like that, I mean, most of the questions, mechanical systems is the category for that. It says, what type of sewage system? If septic or cesspool, what's the age? Date last pumped? Frequency of pumping? Any known material defects? So let's just talk about my house for an example. I built my house, so it's rather new. I had an issue with my septic, not because I actually had an issue with my septic, but because I had a contractor come out for something else and said, I think you have an issue with your septic. And I was like, oh my God, I have an issue with my septic. So then I called a septic company to come out and look at it. And they were like, you need a whole new septic system. And I was like, oh my God, I need a whole new septic system. I just built my house. I'm freaking out. I've had this major issue. I call a septic inspector. He comes out, he goes, no, the septic's perfectly fine. That guy was just trying to sell you a new septic system, but I inspected inspected it, it's good. So like now how do I disclose that to a buyer? Like I didn't actually have a material defect, right? But I certainly did have a company come out and inspect my septic, and I had a company tell me that my septic was awful and needed to be replaced, right? So like now, you know, this is going to be things where, again, attorney involvement, how do we disclose that issue? So as to not have an issue, right? Because if they had a septic issue post-closing, let's just say a year after, and they call the same company that I called to come out to give me an idea of what was going on, they could have said, hey, we were at this house and we have a report where we told her she needs a whole new septic system. I can't not write anything on that line. I have to explain what happened. So, you know, again, this is going to call into question these types of scenarios. It asks about water penetration due to seepage or natural flood event. Then it goes through just like a list of if there are any known material defects with any of the following: plumbing system, security system, carbon monoxide detector, smoke detector, fire sprinkler system, sump pump, foundation slab, interiors, walls, ceilings, exterior walls, siding, floors, chimney. Like, first of all, there's like a whole list. But first of all, what is a material defect? Like now we have to figure out the definition based on a specific situation as to whether that warrants a material defect. And so, you know, they define residential real property, which is helpful for us, but they haven't defined material. So that's going to be now the subjective, it depends answer based on every situation. Just to move on. So let's see if I think we might, I just want to make sure I didn't miss a question here. If a flipper receives this from a previous owner, then flips and sells, does the information on the original form come into play concerning their knowledge? Yes, I would say so. You know, so if they tell you, and I suggested maybe holding on to it and attaching it as an addendum as well to the one that your seller completes. But it says the seller makes the following representations to the buyer based on the seller's actual knowledge at the time of signing this document. Well, if I bought the house and they disclosed to me on this form that, let's say, for example, my septic issue, there was a potential issue with the septic, I was given knowledge, right? So now I would have the same knowledge that I would have to pass on. So it may be helpful to retain this and say, here, I bought this 6 months ago. Here's the disclosure I got. I don't have any further issues. Here's my completed statement, but here's also the one that they gave to me. And then let's see, if the property is in an LLC or an S Corp, does the LLC or S Corp have to sign, or does the form have to be signed by the owner personally? Also a very good question. The entity itself is the owner of the property. So the person that is authorized to sign under the entity, and this is something that I talk about in my webinars, about, you know, just general knowledge, you know, on signing documents, who has the authority to sign off for the LLC or the corporation. So that's important to know, because it would be that person. It wouldn't be like, if I own the LLC, I would be signing as the member of the LLC. I would not be signing a personal guarantee of it. It's me as the member, the owner of that property. So it's the authorized signer, the same person that should be signing the contract. What other options are there aside from litigation after closing during the 6-year window? Oh boy, what would you see? Further negotiations to satisfy an issue, settling out of court, so to speak, or if you were a seller's attorney who has a claim against them, is that something you would recommend? I mean, I don't have it in front of me, but the percentage of litigation that starts that actually goes to trial, you know, is very small. So all of those either are settled, or they've been decided on a preliminary, what we would refer to as a preliminary motion. So in that case, you know, that's probably what's going to happen, right? So like if a seller, you know, does have an issue post-closing and they call up and they say, you know, this turned out, you know, I'm being sued, or, you know, I've been contacted by this attorney stating that they're going to come through with, with papers, if I don't, talk to them about it, yeah, we're probably gonna have to look into the issue. It's gonna be treated like a litigation matter. Look into it and potentially settle it, for some type of, fix. So unfortunately, people are gonna see dollar signs here. Like, people are gonna think, if I sue them, or if I start this process, if I send them a strongly worded letter from an attorney, maybe they'll just go with it. And they'll offer me $5,000 and I can just take the money and run, right? So that's certainly gonna happen. Can the buyer waive the 6-year period? I think that the court probably would void that if they did. So like, if we tried to add a provision that the buyer's waiving any claims, I would question as to whether the court would actually find that legal, since the seller has an obligation to make and stand by this statement. So it, it certainly calls into, a question on it, but I don't know that it would be feasible to do. Okay. What is the lifetime of the form? Caitlin, do you mean like lifetime, like how long they can sue? Because that would be the 6-year period.
If I purchase the house and 10 years later, I put the house on the market and I didn't experience any of the issues of that form, did I still have to pass that form to the next buyer the same way I got it?
Okay, I missed the first part. I couldn't quite hear you. So if you had the listing and you had your seller complete the form, and then what?
No. A buyer purchased the house. and
Okay,
Get the complete disclosure form with some issues. 10 years later, he sells the house and those issues didn't come up. And he has to fill a new form. He
Right.
has to disclose the same issues he was there 10 years ago.
but do they have actual knowledge? That's really the question, is that they have actual knowledge. So if they received a form where the prior seller told them that they had knowledge of this issue, does that create actual knowledge in the buyer at that time to have to disclose that, even though it's 10 years later? I mean, these are all things that are going to have to be sorted out, but I believe that's an argument that could be made, that the seller had knowledge from when they purchased that this was a previous issue. This is all attesting to the history of the property. And then you mentioned a 6-year window. Is that the statute of limitations, or on the contract? How do you terminate the buyer's right to sue? You can't, I don't know that you can really terminate the buyer's right to sue. That's a remedy that they have available to them. The 6-year is the statute of limitations for a breach of contract, which is what this would fall into. Okay, thinking I got everyone. Is anybody else raising their hand that I didn't get to?
Hey, Jessica, can you hear me?
Yep, I can.
I'm Dan Corino. Good to see you again.
Hi, how are you?
I'm well. The question I have is, what happens, what's the remedy if the seller refuses to fill out this form?
Oh, boy. Oh, we're probably gonna see those sellers, huh?
Yeah. we'll see.
Yeah, it's a great question. I mean, they don't have a choice. That's really what it comes down to. So, yeah, the way I look at it is they would face an immense amount of liability. And I don't know that if by the time it got to me, if you said to me, hey, listen, they're being really difficult and they don't want to sell, or they don't want to complete the statement, but we have an offer, my advice to them is going to be, you have to complete the statement. Otherwise, you're going to face potential liability for having not completed the statement. So that's certainly not going to be a good look for them, if they were to get sued. So if anybody else wants to unmute, yeah, you can. Go
Yeah,
ahead.
hi Jessica. Can you hear me?
Yeah. Yep.
Okay, great. So is this really in perpetuity disclosure? Like, even if there's been issues that have clearly been remediated, whether it's rot in a beam or mold in a wall, like a third, fourth owner has to disclose that they have seen reports about the second owner, for example, having remediated an issue, and they have to share that? Or like, well, like, is that what this is coming down to?
I think that the continuous completion of this document and issues that happen, let's say they, you're right, let's say they did their home inspection and they found mold and the seller remediates the mold. In that case, do they have to disclose that when they go to sell this property? And I would say yes, because if it's a question, if it's falling under one of these questions, they have actual knowledge that there was a problem that was remediated. It's just, even though they weren't the ones that remediated it.
Oh, okay, thank you. Yeah.
Anyone else? Feel free to unmute.
Jessica, there's another question.
Sure.
If the seller refuses to fill out the form, would the agent be well advised not to list the property?
Yes, I mean, certainly your broker should give you advice, directly, the brokerages themselves, as to liability. But I don't know that the house, that you would want to get involved in that. Might just be a waste of your time too, which is always a concern. Yeah.
Can an attorney draft a contract without that form completed?
I wouldn't suggest it. It would again, we're talking about timing issues. So if it's a matter of, the seller won't even, hasn't even filled this statement out, and then you're going to have a contract drafted and sent out, that doesn't make much sense. They should have the opportunity to review and further investigate if need be, based on, that's the idea behind the law, is that the buyer has been made aware and has had an opportunity to look into this.
But if the seller refuses, shouldn't there be some kind of addendum or something that says, I absolutely refuse, and you can still move forward? Because then it's still open the same 6 years, right?
Well, but they're outright breaking the law, basically, is what it comes down to.
Okay.
By not completing the statement.
I have a question. Maybe, is there any other agents on the call that have license in states, that regularly do use this disclosure, and kind of like, how do they use it and the timing of it?
Anyone?
Hello?
Currently, I work with REOs, and there's a little exception to that rule.
Mm-hmm.
And I'm still trying to figure out what that is. That's why I'm here.
Right. The exception on a foreclosure, yeah, the seller doesn't have to deliver it if they are the bank. Not if you buy a foreclosure and sell it, then you would have to still disclose.
Am I on the air?
Yes.
Okay. I recently bought in Myrtle Beach, and that disclosure is not, an opinion, it's the law.
Mhm.
And I was provided that when we got the contracts.
Right.
I think many states already use it. I think New York is behind in that, and everybody fills it out. I mean, it's the law. There's no question.
Right.
Okay, thanks.
So just to point out, because I did speak already at a brokerage about this, and they had I had said that, I didn't get into it, but I had said that there is opposition to this. And I'm just pointing out that the New York State Association of Realtors filed a memo of opposition stating that the bill would upend decades of practice, and that there are problems with some of the flood related questions, that FEMA's flood maps are outdated and inaccurate, which honestly, I have trouble using their website all the time. So I get that, that the flood zone information is often inaccessible and unreliable, and that buyers would be better served relying on a home inspector than on a mandatory seller disclosure. So it's all stuff that I would tend to very much agree with, you know, that they filed in opposition. You know, as we all know, you know, there's been no statement that this will be delayed, or that maybe, you know, they won't, you know, continue to implement the law on March 20th. So we have to proceed that that's what's happening. But, you know, that's the truth of it. I mean, it's uncharted territory, as it says right here. And that's really what it is. It's about us sorting through, and how do we do this the best way possible to not only protect our client, whoever that is, seller or buyer, but make sure that we are complying with the law. So, you know, it's going to be a learning curve for all of us. You should all feel free to contact me with any questions that you could have. Again, even if I'm not the attorney on the file, of agents that call me all the time and say, I just have a quick question. I'm sorry, they have an attorney that they want to use, but they're not answering the phone and I just need to know the answer. It's not a problem. I'm happy to help in any way that I can. You know, I can't necessarily give your seller legal advice if they're not going to use me as their attorney. However, you know, if you have a question, I'm happy to help you with the answer. But again, it's probably better to go in there, as the same many of you already do, with your team of people, and just have that team on board from the very beginning, so that we can sort out issues from the beginning, as opposed to down the road when we're already, you know, potentially in contract. So, or at least negotiating contracts. Any further questions? If you want to unmute, go ahead. But otherwise, I thank you all for joining. And your questions were all wonderful. So we'll see how we can work this out and move forward in the best way possible.